Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. When I was a kid, there was a show on television called The Outer Limits.
There is nothing wrong with your television set. Do not attempt to adjust the picture. We are controlling transmission. If we wish to make it louder, we will bring up the volume. If we wish to make it softer, we will tune it to a whisper.
Today, when you watch that show, if you happen to catch some kind of a rerun here on YouTube or maybe on, Nick at Night or one of those old-time TV channels, you look at the special effects that they used in that show and you think, wow, a 12-year-old with a Commodore 64 could probably do the same thing today. It didn't have much in terms of special effects, but it was a great science fiction show, and it had some rather topical and interesting topics on it from time to time. But the thing that I liked best about it is when it would come on, they would give you this test pattern, and they would say, there's nothing wrong with your set. Do not adjust your set. As if, what you were going to see would be so shocking you'd think the TV had gone haywire or something. So keep that in mind. It actually does apply within this context. I'm getting there because today, as you saw from the intro, we are discussing the Supreme Court's decision on the bump stocks. I probably ought to put a note in here for the manual reviewer at YouTube that I'm not at all championing the use of bump stocks or any particular firearm. That's not what I do. I'm talking about the legal effect of a ruling, and this has much less to do with any kind of firearm than it does with the law. And so that's where I'm focusing. Again, it's not meant to glorify or do anything in favor of firearms. I'm just talking about what the law is and what the Supreme Court decided. Well, it's not every day that I'm right, although I'd like to think that it is. My wife reminds me quite frequently that it's not. But when I am right, I do like to say, I told you so. And this is one of those that if you'd asked me about this back when Trump was president and he did this thing, I would have told you then, this is coming back. It's going to be reversed. Don't worry about it because it's completely wrong on the law. And this is not a constitutional ruling, okay? This is a statutory interpretation ruling. The Second Amendment has absolutely nothing to do with this opinion. Everything that has to do with this opinion comes in the form of statutory construction. So, like I said, this is one of those that I can honestly say I told you so, because at the time I knew this was the wrong thing to do, the wrong way to go about fixing this problem. So it's one of the most unsurprising rulings from the Supreme Court ever. Well, why do I say that? Because words mean things. The only way that Congress has to, set forth the information in a statute is through words. And unfortunately, words do not always keep track of where society and technology are going. But they still mean the same thing they meant when they were written. And unfortunately, the only thing that the court has to go by when it interprets a statute is what the language meant when it was written. So this is a case where the president, in this case President Trump, tried to effect gun control by regulation, by saying that a bump stock converted a semi-automatic rifle into an automatic weapon. But Congress wrote the language of the statute at issue, and that's not what Congress said. You're being told that the Supreme Court is out of kilter with this ruling. That's simply not true. So, as they said on the Outer Limits, do not adjust your set. It's working perfectly. Some folks are just upset that they can't impose by executive or judicial fiat what is only properly within the legislative branch of government. So let's look at the opinion. This is one of those easy opinions that you can just read the syllabus on and you know as much as you probably really need to know. In addition to looking at the syllabus, we are also going to look at Alito's concurrence in this case, and we're going to look at Judge Sotomayor's dissent. So here's what the syllabus says. The National Firearms Act of 1934 defines a machine gun as any weapon which shoots, is designed to shoot, or can readily be restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. Now, when this was passed in 1934, what was going on? Well, it was just after the Roaring Twenties. Al Capone, Babyface Nelson, Machine Gun Kelly, all those guys were big, and they were running around robbing, killing, pillaging, doing the things that they wanted to do, and Congress acted to do this National Firearms Act. And one of the things that it placed on a very tightly regulated schedule were machine guns, and machine guns had a definite definition. It is, as it says, any weapon which shoots, is designed to shoot, or can readily be restored to shoot automatically more than one shot without manual reloading. Well, this with a machine gun, a shooter can fire multiple times or even continuously by simply pulling the trigger once and holding it down. This capability distinguishes a machine gun from a semi-automatic firearm because a semi-automatic firearm fires once with each trigger pull. The way a bump stock works is it creates a technique for bump firing. Shooters can fire semi-automatic firearms at rates approaching those of some machine guns. A shooter who bump fires a rifle uses the firm's recoil to help manually manipulate the trigger. It is essentially a recoil-oriented trick that makes it easier for you to pull the trigger faster. Now, I'm going to step out of the legal mode here and into the opinion mode and just tell you that I think bump stocks are a ridiculous idea and not something that people really need and really shouldn't even want to have. And this quote from the body of the opinion, Section 5845B asks whether a weapon shoots automatically more than one shot by a single function of the trigger. The statute thus specifies the precise action that must automatically cause the weapon to fire more than one shot, a single function of the trigger. If something is more than a single function of the trigger is required to fire multiple shots, the weapon does not satisfy the statutory definition. That is the heart and soul of the analysis necessary to decide this case. But the bump stock does not alter the basic mechanics of bump firing. The trigger still has to be released and re-engaged to fire each additional shot. So those of you who do not operate firearms may not know that there is something called a release. And so when you pull the trigger, it clicks and fires the weapon. And then when you let it go, it resets. So in order for it to fire again, it has to reset. So what a bump stock does is it just makes it easier for you to pull the trigger a lot faster. And again, you do that simply by holding your finger still and letting this bump stock attachment move the rifle in your hands, which of course is what throws off accuracy. So for many years, the BATF took the position that these were semi-automatic rifles equipped with bump stocks, and they weren't machine guns. But then they changed the regulation after this Las Vegas killing on October 1st, several years ago, that got 58 people, wounded over 500 more. There are still so many things about that event that are not known. Why the shooter did that, what he had, why he had all the stuff that he had, his relationship to other entities in the government. It's sort of one of those Area 51 things. There's a lot of stuff nobody's ever going to know about it, but that's what happened. So after this regulation passed, Michael Cargill surrendered 2 bump stocks under protest and then filed a lawsuit. And as relevant, Cargill challenged the ATF lacked statutory authority to promulgate the rule because bump stocks are not machine guns as defined by the statute in Section 5845B. After a bench trial, the district court entered judgment for the ATF. In other words, he decided in favor of the government that this could go into effect, that it was legal. The Fifth Circuit initially affirmed, but after they requested rehearing en banc, after an en banc rehearing, the majority agreed that it's ambiguous as to whether a semi-automatic rifle equipped with a bump stock fits the statutory definition of a machine gun, and resolved that ambiguity in Cargill's favor. So it goes up to the Supreme Court, and they say, held, ATF exceeded its statutory authority by issuing a rule that classifies a bump stock as a machine gun. A semi-automatic rifle equipped with a bump stock is not a machine gun because 1, it cannot fire more than one shot by a single function of the trigger, and 2, even if it could, it would not do so automatically. And then it goes on to explain, a semi-automatic rifle equipped with a bump stock does not fire more than one shot by single function of the trigger. The phrase single function of the trigger refers to the mode of action by which the trigger activates the firing mechanism. The ATF argues that a shooter using a bump stock must pull the trigger only one time to initiate a bump firing sequence of multiple shots. This initial trigger pull sets off a sequence, fire, recoil, bump, fire, that allows the weapon to continue firing without additional physical manipulation of the trigger. This argument rests on the mistaken premise that there is a difference between the shooter flexing his finger to pull the trigger and pushing the firearm forward to bump the trigger against his stationary figure. Moreover, ATF's position is logically inconsistent because its reasonings would also mean that a semi-automatic rifle without a bump stock is capable of firing more than one shot by a single function of the trigger, yet ATF agrees that this is not the case. ATF's argument is thus at odds with itself. They go on to say firing multiple shots using a semi-automatic rifle with a bump stock requires more than a single function of the trigger, because again, the trigger has to be pulled, it has to reset, and then it has to be pulled again. The ATF argues there's no meaningful difference between holding down the trigger of a traditional machine gun and maintaining forward pressure on the front grip of a semi-automatic rifle with a bump stock. This argument ignores that Congress defined a machine gun by what happens automatically by single function of the trigger. Simply pressing and holding the trigger down on an automatic rifle is not manual input in addition to the trigger's function. So they operate differently, is what the court's saying there. And as a result, they affirmed the judgment of the Fifth Circuit, interpreting 5845 to exclude semi-automatic rifles equipped with bump stocks. Now, Thomas wrote the opinion, Roberts, Alito, Gorsuch, Kavanaugh, and Barrett joined, and Alito filed a concurring opinion. And for those of you who may be interested in how all of this works, there are some interesting diagrams and pictures in the opinion that show how all of this is carried off and how it works. So this is Judge Alito's concurrence. And he says, I join the opinion of the court because there is simply no other way to read the statutory language. There can be little doubt that the Congress that enacted 26 U.S.C. section 5845B would not have seen any material difference between a machine gun and a semi-automatic rifle equipped with a bump stock. But the statutory text is clear, and we must follow it. The horrible shooting spree in Las Vegas in 2017 did not change the statutory text or its meaning. It did, however, strengthen the case for amending 5845, but an event that highlights the need to amend the law does not by itself change the law's meaning. There is a simple remedy for the disparate treatment of bump stocks and machine guns. Congress can amend the law, and perhaps would have done so already if ATF had stuck with its earlier interpretation. Now that the situation is clear, Congress can act. And then this is the this is the dissent. On October 1, shooter opened fire from a hotel in Las Vegas. Goes through all of the things that happened in Las Vegas. It talks about the history from 1934. Today, the court puts bump stocks back in civilian hands. To do so, it casts aside Congress' definition of machine gun and seizes upon one that is inconsistent with the ordinary meaning of the statutory text and unsupported by context or purpose. She's wrong on that. I read you the text. The text is absolutely clear about what constitutes a machine gun. She simply would read it differently. She would torture the text in order to reach the result. This is a frequent problem with this side of the aisle with respect to the court. Sotomayor, Kagan, Jackson, they all opt to work off of feelings as opposed to deal with the hard realities of the law. Throughout her opinion, Judge Sotomayor makes some statements that I think she will probably come to regret later. One of them is that semi-automatic weapons are not machine guns under the statute. Well, if a semi-automatic weapon is not a machine gun under the statute, there goes her entire analysis on the definition of a machine gun, because the bump stock does not alter in any way the trigger or anything else of the firearm itself. It merely changes the way the recoil is processed by the firearm and allows the person to stick their finger in a place to make the firing occur more quickly. So again, this is frequently what happens when people who do not understand firearms and who do not shoot firearms try to make laws or try to make decisions about firearms in the absence of any actual hard knowledge about the subject. The fact of the matter is, just like with mifepristone, the abortion drug, there are some things that have to be left to Congress. So what do we have here? We have a case where the definition in the statute is held to mean something. SCOTUS is giving the language used the plain and ordinary intendment of the language, and that is not surprising. As Alito said, there really is no other way to read the statutory language. Courts across the land do this kind of analysis every day. It's called plain language analysis. They look at the plain meaning of the words and they apply the plain meaning. If they look at an insurance policy and the insurance policy says a business is a for-profit entity on the insured's property, well, a for-profit entity that is not on the insured's property is not a business under that policy. And that, again, is because words mean things. Just as with the case involving the abortion drug, like I said a few days ago, if you want different policy choices, you have to go to Congress to get those choices made. I told everyone the day this regulation was written it would be reversed by the courts, and I was right. Very much like the abortion ruling, it's a plain language ruling, and it's strictly on the law. There's no politics in this. This is solely and exclusively a statutory language analysis, and it's right on the money. So that's what I have for you today. If you have any questions, drop them in the comments down below. You can always email me at the address above, and if you have the opportunity today, go out of your way and do something nice. So this morning, my wife knew that it was Monday. They were down a few people at the office, and she asked me if I would come in and answer the phone for a few hours. So that's what I did. Before I left, I went and got some chicken strips for her to eat for lunch. And while I was going out, I asked several of the other staff if they wanted anything, and I got them lunch too. Again, you just go out of your way to do a nice thing for somebody. It does make the world a better place. After you do something nice for somebody, come on back here next time, join us at the beach, and we'll talk about more of these Supreme Court opinions maybe. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.